which hasn't been covered, is just to talk more about the terms of the settlement, the amounts, and what happened with regard to communication about Bowman Gilfillan or Bowman's, their involvement, the application in the court, just to confirm the communication that they didn't expect when they were told by their opponents, those are not the terms on which you are supposed to settle, that kind of thing. Other than that, I'm not sure what more. So I think because it's really about how the matters came to be settled on the terms on which they were settled. Yeah, okay. We should be able to do that within 30 minutes. Okay. Remember to switch on your mic.
Mr. Mogashoa, we were on paragraph 32 dealing with the question of the confidentiality provisions.
Correct.
And you were told to include those in the offer that was made.
Yes, in the offers that we...
Of course, as you pointed out, you were waiting for written confirmation of your instructions.
That is indeed so.
Now, before we get into that, you might remember much earlier, I raised with you that Mr. Dingizwayo had said that there was a secret agreement.
Yes, I remember we
And
debated.
you made the point, but it was never secret. But I just want to point out that in a sense, I suspect that's what he was talking about, that the agreement was not to be made available to anybody but the parties involved, and in particular, legal.
You're quite correct. It may have been in that context, actually.
Yes.
I'm looking at it that way for the first time.
I just yes. thought, in fairness to him,
Yes.
that it wasn't as if he was making a wild allegation.
I fully understand.
All right. Now, you were then waiting for instructions from them. Did you get written instructions?
Yes, I believe it may have been on the very same day, on the 15th of December,
Yes.
that I received written instructions from
Okay.
PRASA. I think it will be my very first annexure
Yes.
as I deal with it on paragraph 33 of my own affidavit.
Yes, and that's at page 21 of the bundle, of your bundle. That's MM1, am I right?
Correct. This is the one.
So these are the instructions, the written instructions now that you received.
Correct.
And they were coming from Mr. Linde Kayazite, and I see that he is signed there as Group Company Secretary.
Correct. The letter came from his office, but I suspect it was transmitted through to us by his secretary or PA, Lebogang Matsimela.
But I think the chairperson was emphasizing, Ms. Mogashoa, that the capacity in which Mr. Zide signed was as Group Company Secretary.
Correct. I see that on page 23.
Yes. And the perhaps relevance of that is you might remember that in the earlier communication on the 28th of November in her memo, she wrote to Mr. Zide in his capacity as CEO, you might remember. I'm just taking you back to that.
I remember that.
And she made the point, as CEO, you would have given those instructions.
She made that point, correct.
All right, so now we've got Mr. Zide's letter to you, and are those the instructions you've received?
These are the instructions I received. That is indeed so, Chair.
Yes.
And were they in line with what you had been told at the meeting of the 15th of December, at that meeting where you were told about the amounts for settlement?
The amounts may differ slightly and perhaps a bit more significantly.
Yes.
In some instances. But because I left the meeting with my own written notes,
Yes.
I accept that the written instruction then represented
Yes.
properly what PRASA wanted me to
Yes, okay.
make an offer on.
Okay. Well, it may be important for record purposes to just indicate that this letter from Mr. Zide and that in paragraph 2, he confirms that at the meeting of 15 December 2017, between yourself and the chairperson of the interim board, you were instructed as follows. So the letter seeks to, or purports to confirm what Mr. Zide believes you had been told at the meeting.
That is indeed
Is that
so.
correct?
That's correct.
And then the first group of cases relates to CIRDP consulting engineers. And in regard to the one matter case number 74281/15, your instructions were to hold that matter in abeyance pending further instructions. Is that right?
That is correct.
Just want to point out, if you look at 31.1 on page 13 of your affidavit, Mr. Mogashoa, and keep your finger on page 22, you'll see the case number there is 479,597 at 31.1.
You mean the first case?
Yes.
Yes.
All right. And you'll see that that is reflected as 2.6 on page 22.
That is indeed so.
And I'd just like you to tell the chairperson what the amount is in 31.1.
The amount in 31.1 is 17,178,853 rand.
And the amount that you were now instructed to settle at?
It is the amount that's reflected in paragraph 2.6 of the instruction letter is 19,583,778 rand, 42 cents. But I see here,
Says
in the
including
letter
VAT.
of instructions, it says it's VAT inclusive.
In your affidavit, does it say excluded, VAT excluded?
I do not say.
It doesn't, oh,
No, I do not say.
Okay.
I think there was no such distinction made when we were in the
Yes.
meeting of the 15th.
okay.
And the other amounts appear to be the same, from 31.2 to 31.4, and the ones at 2.3, 2.4, and 2.5 on page 22.
That appears to be so, yes, the amounts seem to be the same, the three remaining amounts.
Well, was there anything unusual about the terms on which you were instructed to settle these matters in your experience, or was there nothing unusual?
I'm not sure if Chair is referring to the figures themselves or the computation.
Whatever
thereof,
it is,
or-
if there was anything you found unusual in relation to being instructed to settle the matter on these matters on these terms, is there anything you found unusual in your experience as an attorney?
Well, I would avoid talking about the computation of the figures, but it doesn't happen often that we would be instructed to stipulate in an offer we make that it carries some confidentiality. And I wouldn't be sure what the considerations were
Yeah,
at that time that PRASA thought it proper that it places such a condition on the tender itself. Although, as I say, it has happened before in some of the matters I've had to deal with in the past. That, especially if it is an offer purely to settle, or if it's an offer of compromise, that the details, especially if there are other related claimants, for example, that perhaps emanate, whose claims emanate from the same cause of action. It's not unusual or completely unusual for a defendant to want to have separate, if one may say, confidential settlements with each of the parties, as the case may be. I don't get to prepare
yeah,
tenders and say they are confidential. If it has happened,
yes.
I can count the times.
Yes. And what was the relationship between the amounts on which you were instructed to tender to the other side and the amounts that may have been claimed by the CIA companies in their summonses? Did you take the trouble to check how they compared?
It was my observation, Chair, that the figures were more or less the same. I mean,
Yes.
you didn't have a situation where 15 million was claimed and 3 million was tendered.
Yes.
Just by looking at the figures and you compare them to what the total amount claimed is on the
Yes.
particulars of claim,
Yes.
as may have been amended. So
Yes.
the settlements were close to what was claimed. I can
Yes.
safely say so.
Yes. In your experience, is that quite normal when you talk about a settlement? In your experience, how many years had you been in practice by then?
I was admitted in May of 2000, so it's 20 years now.
Yeah. So you had about 17 years at the time of the settlement, more or less.
Correct.
Yes. In your experience, was it quite usual? Has it been usual in your experience to have matters settled on a basis in terms of which the defendant
It's being sued.
pays or tenders to pay either the exact amount claimed or very close to it? Is that something that you have found quite common in your experience over the years?
Settlements would, in my view, be a product of negotiations between the parties. If I were to speak about the extent of our firm's involvement, that did not happen. I was not asked, or let me put it differently, I was not involved in the computation
Yeah.
of the final figures, and therefore it will be difficult to say no, this amount should not have been tendered, but that should have.
Yeah,
I did not do the exercise either
yes,
after I was given such instructions, because I
Yes.
accepted that PRASA was satisfied, or where the instructions came from, the relevant officials were satisfied that what they wanted me to tender is what they thought PRASA was liable for.
yes, no, that's fine. I was asking a different question, and that's where I want you to assist me.
Yes.
I haven't been in practice. I left practice about 23 years ago. So, and when it comes to settlements, as you know, judges normally don't get told what the settlement was. So, but my reaction when I noticed that the amounts you were instructed to tender seemed to be exactly the same amounts claimed in the summons, at least that was my impression. That didn't strike me as a settlement as one would normally expect. But maybe it's because I've not been in practice for over the past 23 years. Maybe things have changed. Are you able to assist me to say, well, things have changed, you don't know what is happening out there now, this is normal? My experience was that there would be a kind of, if you're talking of a settlement, you would be looking at about a very different amount from the amount claimed.
We generally say that a good settlement is a settlement out of which none of the parties are happy, which means your plaintiff does not get quite what they may have been looking for, or your defendant doesn't pay, they find themselves paying more than what they may have bargained for. So yes, Chair, you would find that we don't ordinarily normally pay what is claimed for in the particulars of claim.
Okay.
Just
Well,
one,
Mr. Soni might have better experience because he's still in practice, so.
yes, I can say that law hasn't changed since you.
Yeah,
There's just one other clause that I'd like us to look at, Mr. Mogashoa. It's at page 22 under C.
or maybe you might or might not be able to comment on this, Mr. Mogashoa. I'm sorry, Mr. Soni.
Yes,
I think Mr. Dingiswayo, if I'm not mistaken, said in his affidavit, or maybe also in his evidence, that this was not a settlement, it was capitulation. Do you want to comment on that? Eh?
I remember seeing that. Well, if you compare the figures of the tender to the figures as they may appear in the particulars of claim, one would look at it that way, that it's a capitulation. And I think it's even more confusing when such matters have had some life of being defended, and then after 2 or 3 years, then it's a settlement, and it's a settlement of the full amount. It can create some uncertainties.
Of course, what one can't deny is that if indeed PRASA had no defense to the claims, it may well have been a reasonable thing to pay at that time and save all the legal costs that would come with the arbitration, isn't it?
I
agree.
agree.
If PRASA had no defense.
I agree
Yeah,
fully with
yeah.
that. If we couldn't
Yes.
find anything wrong with the
Yes.
invoicing or the figures,
Yes.
I accept that
Yeah.
yes, one would have
Yeah.
had to
Yeah.
make
Okay.
that kind of a settlement.
Okay. I'm sorry, I interrupted you, Mr. Soni. You had a question.
I've got my point again, Chairperson. If you look at paragraph C, you might remember the Chairperson asked you, was there anything unusual? And you've debated that issue with the Chairperson. But have a look at paragraph 2.c regarding the interest that was to be payable. .7 on page 22.
Correct, I see that.
What does it say?
Well, it simply says that interest must be calculated from the date of issuing the summons instead of being calculated from the date of the issuance of the invoice itself,
Okay.
or invoices.
Now, based on this instruction, what did you do? This written instruction?
What would I do?
No, what did you do?
Oh, yes, yes. Okay.
So maybe before that, so to sum up, your instructions are tender, it's either the amounts claimed in the summons or something more or less the same, and tender interest from the date of summons, for the date of, yeah, from the date of summons. That's what it says. So far, it looks like the only thing that is not mentioned on your instructions is costs. Is that right?
That is correct.
Yes. It looks like the instruction letter said nothing about costs.
The instruction letter indeed did not say anything about costs.
Yes. Okay. Mr. Soni asked you a question about the interest. You might wish to repeat that question about interest, yeah.
Sorry, I was asking about what happened next year.
Or what happened
Oh,
next,
yes.
yeah.
Oh, yes, Chair, what then happened is I then formulated the tenders in line with this letter of instruction, and I may have sent out the tenders on the same day or the day thereafter. I remember we produced two documents, one in respect of the CIR rail solutions matter, the 19 million rand tender, and separately from that, and in respect of the three claims under the CIRDB consulting engineers, we issued another tender. So it was two tenders, one with details of the three claims and the other one with the details of just this one claim under case number 47597 of 16. I don't know whether I dispatched with the tenders the same day on the 15th or the next day on the 16th, but I remember we then managed to structure the tenders in line with the instructions and transmitted them electronically to our opponents.
Yes. And how did they respond to the tenders you had made?
We don't have your letter in which you made the tender, eh? I don't see it here. We don't
It's
have.
not.
Okay, all right. But you made a tender in accordance with your understanding of your instructions.
Correct. That is exactly what happened.
Yes.
And I think I do say in my affidavit that a day or two thereafter, I received a letter which I probably refer to in my affidavit.
It's at paragraph 34, MM2.
Yes, in which my opponent acknowledges receipt of the tenders made, but then they went on to raise an issue to do with interest because I had not included interest in the amounts that were part of the first tender, tenders issued out.
Okay. So that they address in paragraph 3 of their letter, which is at page 25 of the annexes to your documents.
Correct, that is what the letter
So
reads.
just read that paragraph.
I'm sorry. Are you at 25?
At 25, Chairperson. This is
Okay.
the opponent's response to Mr. Mogashoa's tenure.
Okay, we are now dealing with Annexa MM2, which appears at page 24, and it is a letter from our Matopo attorneys dated 18 December 2017. Yes. Before you read what Mr. Soni says you should read, I see in paragraph 1.1 of that letter that Matopo attorneys say we represent CIRDB Consulting Engineers Pty Limited in liquidation and CIR Rail Solution Pty Limited hereinafter collectively as our client. I thought that there were different attorneys for the liquidators and different attorneys for CIR Rail Solution. Was that not the position?
No, that was not the position, Chair. You would recall
That was or that was not?
it was not the position.
Okay.
You would recall that earlier on, I did mention that soon after gaining information that the CIRDB was
Under liquidation.
under liquidation, we then asked for the requisite mandate and authority from Mr. Matopo in order that we get satisfied that he continues to act for CIRDB even when it is under liquidation, and we were provided with such mandates.
Around about when would that have been? You were now talking about 17 December 2017,
It may have been around May or June of 2017.
or much earlier.
Much earlier, soon after, we became aware of the liquidation process against, or in respect of CIRDB in April, around middle of
Yes.
April. I think we do say that on the 17th of April or so.
Yeah, but I thought Mr. Portes, when he gave evidence here, and I thought I read in the papers that at the time that he was talking to the PRASA chairperson, at the time Mr. Portes was talking to the PRASA chairperson, and there was communication about settlements, which I think would have been around November, December. Around that time, I thought Mr. Portes said there was a Mr. Krause or somebody who I thought represented the liquidators. And the impression I had was that Krause attorneys represented the liquidators and Matopo represented another entity. That's why I'm picking this up and I'm surprised by it.
Yes, we soon after gaining knowledge of the fact that the DB or CIRDB aspect of the CIR group of companies had been placed under liquidation, we naturally approached Mr. Matopo and inquired from him if he continued to act on their behalf, given that they may now be under a different
Under someone else's control.
legal personality, under someone else's control and so forth. And I think after a while, he came back to us. I just don't have the documents in front of me, but I remember very well, because we were not going to move on litigating with him in circumstances where our client was not satisfied that he continues to enjoy the mandate of the CIRDB consultancy, which was under liquidation at the time.
So is the position that earlier on, Matopo attorneys represented all the CIR companies that were involved in these claims initially?
That has always been the case, correct?
And then you say at a certain stage, April 2017, you became aware that CIRDB Consulting Engineers was under liquidation and you sought proof of authority and that was supplied in due course.
It was made available.
Yes.
Correct, Chair.
Now, does that mean there are no other attorneys that, as far as you know ever represented one of the CIR or one of the CIR companies in regard to these claims while you were involved for PRASA?
Around the time subpoenas were issued by the Liquidation Commission or Insolvency Commission, as we may want
The
to call it,
inquiry here.
there was a law firm that had issued those letters on behalf of the liquidators. But our office continued to communicate with Mr. Matopo's office on the basis that his firm still represented the company in liquidation and the CIR, the CIR Rail Solutions Company.
And Mr.
But if-
Bottas had been briefed by Matapo attorneys.
That was my impression.
Yeah, okay.
But if you look at communication around the time the offers were accepted, Mr. Bottas seems to now make a distinction between the company in liquidation and CIR Rail Solutions, and I suppose he went on to provide us with two different accounting details or bank account details into which PRASA would have had to pay the amounts. And this was simply because he says that the other company
Was not
had
under
to be
liquidation.
paid through a different trust account than Matopos, as may have been the case in the CIR Rail Solutions case.
Well,
Chairperson, you've picked up something very important, and I must apologize for not picking it up. But if we look at page 27, you will see that this letter from Mr. Matapo says that the amounts must be paid into Mr. Krause's trust account at
Oh,
the bottom
yes.
of page 27, Chairperson.
yes.
Both the amounts must be paid into Mr. Krause's trust account.
Or both amounts, actually.
Yes,
That's very strange.
it is. And I'm sorry I didn't pick it up,
Yes.
Chairperson.
Can you see that, Mr. Mogashoa?
I can see that, yes. It says in both instances, the account of Kraus trust account. It may be different account numbers, though, I don't know. But yes, I see paragraph 9, 9.1 and 9.2.
Would you know whether Kraus Incorporated were attorneys or was it a firm of liquidators or what? Would you know that or not?
I'm not sure about
Yes,
that.
you never dealt with them directly.
I had not dealt with them until the time
Yeah,
that we attended the commissions inquiries hearings in August.
yeah, it's a little strange.
It is.
Yeah, normally attorneys would let payment be made into their trust account to pass the matter to the client. Or otherwise, I guess it would go to the client, but Kraus is not the client.
Yes.
But a distinction is made, because if you look at paragraph 9.1, Chair, it says CIRDB in liquidation. So it is not clear, I suppose, to all of us, why
Well-
paragraph 9.2.
You see, paragraph 9.1 relates to a company that was in liquidation. Paragraph 9.2 relates to a company that was not in liquidation, but payments to both companies was to be made to the same entity, entity's trust account, Kraus Incorporated.
Yes. I see.
It's strange that in relation to the litigation, Matopo attorneys acts for both, and yet when it comes to payment has to, in regard to both, must go to somebody else that at least we seem to know nothing about. At least you knew nothing about
I
House
take the-
Incorporated.
I take the point.
Yeah,
Mr.
yeah.
Chair.
So I should look a little more carefully at the papers for next time.
Yes,
Because I
yes.
know there is a letter that Judge Makubela referred to from Kraus attorneys, saying that
Yes.
she had received a letter from them.
Yes.
I just can't
Yeah, it
put
might
my
need to
finger
be
on
checked.
where
yeah.
exactly it is.
Yeah, yeah. Yes.
I just want to go to paragraph 3 now, Ms. Mogashoa, at page 25. Because this is what Mr. Matapo writes to you. Could you read that into the record?
He says on paragraph 3 of his letter,
Yes.
your client, PRASA, did not instruct you to submit an offer or tender to our clients in respect of the capital amounts only. Your client's specific and express instruction to you was to submit an offer or tender to our clients which provides for payment of interest, a temporum RAI at the rate of 9% per annum, calculated from the date or dates upon which the respective summonses were served on your clients.
What was your reaction upon receiving that letter? You'd been instructed to issue a tender, which you did. And now you are told, but the tender is not in terms of your instructions. Well, what was your reaction to that?
I think naturally my first
You
reaction was,
deal with it in paragraph 34
yes,
of your affidavit,
and that is on page,
at page 14. So just after MM2, which is in bold, do you see it?
yes, paragraph 34.
I'm sorry, you are speaking away from the mic.
Oh, yes.
Start afresh, and so that what you say will be recorded.
Okay, Chair. Must I continue now?
Yes, just but start your response afresh, because I don't think it was captured. Whatever you said, I don't think was captured earlier.
Okay. Paragraph 34 of my affidavit. I think on the paragraph, I'm simply summarizing what I'm saying was a bit of a challenge for me, in that I had made a tender, and when my opponent writes back to counter propose, so to speak, reference is made to the fact that my tender is not in line with the instructions I had expressly received from my client. But I think I make the point as well that I said to my opponents that I would, in any event, irrespective, just go back to my client and confirm their instructions in as far as the issue of interest is concerned.
Yes. But I'm raising a slightly different point.
Yes.
How would they know what your client had instructed you to do? I mean, we know now that they did know. Did you ever find out?
I was equally taken aback by that. You may see that at the end of paragraph, I'm not sure if I took that issue up with them.
I don't think you did, certainly not in your affidavit.
I don't think I did in writing, or maybe it's correspondence I did not want to at the time deal with. But yes, I found it a bit troublesome that my client's instructions were not only known to me, but from the reading of the letter of Mr. Matapo, they as well had been placed in possession of the same letter that was addressed to me.
So can I give you some background to that? When Mr. Bothus gave evidence, he said that this letter had been WhatsApped to him. He received this letter by WhatsApp from the chairperson of the board. That was his evidence.
Oh, okay. All right. I did not get to see any of the submissions he made.
No, I understand.
It explains how the letter got to them.
All right. Now, having received that letter, the MM2 from Mr. Matopo, what did you do?
I then immediately approached Mr. Zide, client, and I indicated to them, and I may, if you allow me to get to MM3,
Yes.
because I may have said to client that it's concerning
That's at page 29. MM3 is at page 29. And your email is the second email on that page.
but I think the attachment does not quite deal with the concern I had.
Yes.
I may have simply forwarded the letter to client, and client then gave me instructions to investigate how to incorporate the interest that is referred to in their initial letter of instructions.
Okay. And did you do that?
Yes, we went on to instruct our accountants to give us a table of such figures as it was required that they include interest. They made such figures available to us, and I forwarded the figures to Mr. Zide with recommendations that I had satisfied myself with the interest incorporated, and these instructions were that I then should proceed to revise the offers to include the interest that then was calculated on the basis of the capital amounts.
Now, that offer then was sent to Matapo attorneys.
We then sent the offers to our office.
What was the response to the offer? Well, firstly, from whom did you get a response to that offer?
I may have received a response from Mr. Brotas.
If you look at MM4 on page 30, this is the top, the top half of MM4, page 30.
Yes, I see that.
Now, that's an email from Mr. Botus dated when
Dated the 21st of December.
and to whom is it addressed?
It is addressed to Tepa Matopo, but we are carbon copied.
Well, just read the names of all the people who are carbon copied.
Okay, people who are carbon copied are Tepa Matopo, Nabeka Zimbabwe, Madimpe Mogashoa, TAN Makubele.
And who is that?
This would be the chairperson.
Yes. And you'll see there's also Mr. Krause.
Mr. Krause is CC'd there as well, yes. And Hannes from Tswane Trust.
Now, in essence, what does Mr. Botus say in regard to, well, it's a strange thing. The email is from Mr. Botus, but if you look at the bottom, who signs it?
Yes, I see it says Matopo Tennis.
Yes. Now, what is the essence of that email?
I see that it refers to the offers we made. And the first point they make, the email makes, is that PRASA's settlement offers are accepted. The email further makes reference to the issue of interest. And I think it repeats the same debate I had with Mr. Matopo around interest and inclusion of interest in the figures. Mr. Botas goes on to suggests that payments be made into Kraus Inc.'s trust account, and that he hopes that our client will expedite the payment issue.
Yes. Now, what was the next thing that happened in regard to those communications? And you'll actually find that in MM5 at page 31.
All right, what I see on page 81, if I may proceed.
Yes, yes.
What I see on page 31, annexure MM5, is that on the same day I received an email from the chairperson in which she says that, "Dear Madimpe, thank you for the update. Mr. Zide, please attend to finalize the matter with regards to payment." And this may have been because her email was in response to mine that I had sent earlier.
Is that the email just under that?
Yes, in which I say, but this is an email addressed to Mr. Bottas.
Yes, sorry.
And everyone else. But if I send this in reply to Mr. Bottas, then the chairperson would have received it.
Yes.
Because she was carbon copied.
I should have referred you to go back to page 30, and in the bottom half, you'll find an email from yourself.
Oh, yes, that's MM4.
Yes. And what does that say? Well, it doesn't say to whom it's addressed. It seems it was sent from your iPhone.
It could be. It says, good morning, says. That's the 1023 email.
Yes.
It says, good morning, says, attached are revised offers in respect of matters with case numbers. And it's the 4 case numbers in respect of which the offers were made. Kindly obtain instructions from your clients and revert.
And it's in response to that offer that Mr. Bottas says we accept the offer.
So then I think then Mr. Bottas' email of 1121 is in response to mine at 1023.
Yes.
Then I then see that what happened here? I'm looking at the last email on page 30. 1125.
Yeah, that email is incomplete. It's not.
Yes.
Anyway, let's not get bogged down. What we do know is that the offers were accepted, and the chairperson told Mr. Zide to deal with the question of payment.
Correct.
Matopo attorneys raised the issue of interest in response to your first offer or tender. But I thought that the instructions you had received did include that you must tender payment of interest from the date of summons. Is the position that your first tender did not deal at all with interest, or is it that you said interest would be calculated from a date other than the one that Matopo attorneys understood you to have been instructed to work on?
It did not. The offers did not at all deal with interest. And I think it was just inadvertent on my part.
Yes, because...
Not to include interest. I may have missed that part when I formulated the offers at that time.
Yes, but subsequently you saw that it was there.
I saw that it was there, but you would see that I contacted clients to say, look, this is what my opponents are saying. I'll just rework to include interest. Yes.
Okay.
All right. Then you say that at paragraph 36, on the 8th of January, you received a letter from Mr. Matapo, indicating that they have a proposal in respect of the matter that was not included in the settlement. Remember, there were 5 matters. 4 were settled. What
Correct.
did you do with that offer?
You mean the letter?
I mean, that letter.
I sent it to client.
And what was the response from client?
Let me see what my affidavit says about that. And I believe that the offer made proposals on how we could deal with that particular case. It's case number 74281 of 2015. I say that despite that this letter was forwarded to PRASA for their consideration and instructions, no communication has since come forth from client.
Okay. Now, the rest of paragraphs 37, 38, and 39, 38 and 39, deal with the fact that certain communications were made to the arbitrator relating to these offers.
Yes, that is it.
And then in paragraph 39, you deal with a message you received from Mr. Zide. What was that in connection with at paragraph 39?
Okay, Chair. The point you make earlier about the fact that the rest of the paragraphs, 37 and 38, dealt mainly with the communication between my office and that of Mr. Matopo, and further with communication between Mr. Matopo's office and that of retired Judge Brand. Then come into flow with what I say in paragraph 39. In essence, Mr. Matopo was getting frustrated with the fact that PRASA was not making the payments following the acceptance of the offers, and he then started engaging with the judge in order that we make, and in anticipation, of course, further, of the arbitration dates that we're approaching in March. He suggested that the parties approach Judge Brand and present to him that the parties have arrived at settlements in respect of some or most of the matters, and that they wished that such settlements be made arbitrators' awards. I imagine at the time the thinking was that they then go on to make them orders of court if the issue of non-payment continued.
Oh.
So
that communication is sent to you, they want to make it, and they want to make the settlement into arbitration awards.
correct. So it will be communication with Judge Brand, but I'm CC'd and copied.
Yes. What did you do when you were copied?
So every time I would receive such communication, I would forward all of the communication to Mr. Zide.
And
So
in regard to that communication, what was the communication from him to you?
in paragraph 39, I then deal with, I had been, Judge Brand was in Gauteng at some point, and I think he had other matters he was running with. Mr. Bottas, or Advocate Bottas, managed to arrange that the parties see him on one particular day. Now, it has always been my position that I wasn't going to act or do anything unless I'm instructed. So I think it's a text message that I'm referring to in my paragraph 39 that I received from Mr. Zide, confirming that that day I was then instructed to proceed and participate in submissions to Judge Brand and make the settlements arbitrators awards as consented to by both parties.
Okay, have a look at page 41. That's the message you referred to at paragraph 39. Page 41.
Correct, the first message.
Yes. And what does that message say?
The message was from Mr. Zide, and it was addressed to me, and it says that, yes, Mogashoa should confirm that the settlement be made in order and proceed with arbitration on the one that had outstanding issues.
And
And
then
Mr. Zide goes on to say that that's from the chairperson.
So what did you understand from that?
I understood that my instructions were that I proceed to see Judge Brand with Mr. Waters and make the settlements the arbitrator's award or consent thereto. And further that I present to the retired judge that the only outstanding matter that the parties had to deal with, perhaps at the scheduled arbitration, was that parties could not settle.
And from whom was that instruction that it be made an arbitration award?
From Mr. Zida's email, the text that I'm looking at here, Annexure MM9, the message by him to me may have been from the chairperson. It is from the chairperson because he says that it's a message from the chairperson,
Yes.
from his second text to me.
So in a direct answer to my question, from whom was the instruction that it be made an arbitration award?
From the chairperson.
Then you say that there were further instructions given to you, and these were at at page 42, MM10. Oh, sorry, not instructions, but you then received applications to make the arbitration awards, orders of court.
Yes, I think the
That you
issue
deal
of,
with that paragraph 40.
yes, the issue of non-payment continued, and then we were served with on behalf of PRASA, we were served with the applications to make.
I'm sure, Mr. Son, you can go to that strange feature about that, because none of that is disputed.
Okay.
What happened, yeah.
Yes.
There was just this strange feature about the authority. I think that's the
Yes.
only thing, as far as I can think of,
No,
that's of
no,
importance, yeah.
I'll just do one small thing and then I'll explain
Yeah.
why I'm going there.
No, that's
And
fine.
at paragraph 41, you say you received a call from Mr. Ndingizwayo.
Yes, on the 5th of March.
And what was that call about?
He said to me that he had received, I think he was talking to a colleague, not at PRASA though, on issues unrelated, and the colleague made him aware that Siyaya had enrolled 4 matters. for
Well, those are
hearing.
the matters that you had sent in to PRASA that we had just talked about.
I had sent the 4 applications
Yes.
to PRASA already, to Mr. Zida's office to say, here are the applications, what do you want?
After your conversation with Mr. Ndingizwayo, did you and he hold a meeting?
Yes, Mr. Ndingizwayo then asked for copies of the applications, which I forwarded to him accordingly, and then I was invited to a meeting at which I think Mr. Malepo, who was the acting CEO at the time, was present, and Ms. Ngoye was present, and Mr. Ndingizwayo was also present there. I went to the
You
meeting
say
with
in paragraph 42, Mr. Zide was also present.
Mr. Zide was part of the meeting, yes.
Yes. And what happened at that meeting?
At the meeting, legal presented to Mr. Malepo that the settlements, as may have been referred to in the applications themselves, had been entered into without legal's involvement, one, and two, that the chairperson did not have the authority to get PRASA into such settlements as may have been alluded to in the applications themselves.
And
Was
what,
this on the 8th of March 2018? In terms of time frame, I see you seem to say so around that time.
Yes, I think the date of the meeting is 8 March 2018,
Okay.
according to my affidavit.
and all of this happened on the 8th of March that you're talking about now.
I may have received Dingizo's call earlier, but the meeting took place on the
On
8th
the
of March.
8th, yes. You say you met him on, I mean, you got a call from him on the 5th.
Oh, yes.
So this is the 8th. Now, in light of the fact that you had been part of the settlement on the basis of instructions received from the chairperson, what was your further involvement in this matter?
Ms. Ngoye made a valid point at the meeting that another law firm be instructed to carry on with the instructions, more so because there was a need for them, an identified need at the time for them to oppose the applications which the applicant had enrolled in respect of the 4 matters. I can't remember what the date was.
It was the 9th.
That the applications stood to be had. Because obviously I'm the one who had been instructed in all of the processes that led to that settlement at the time.
And what was the conclusion at the end regarding your further involvement?
The conclusion was that another law firm would be briefed and that I should assist with handing over my own set of papers to this law firm. I think it was Bowman's.
Yes.
And that is exactly what our firm did. We filed the relevant notices of withdrawal.
And you withdrew formally?
We withdrew formally. Correct.
You have no further knowledge of what happened? I mean, no personal knowledge of what happened in this matter in court?
Well, if my recollection serves me well, there may have been denied I think they opposed the applications, but orders were granted, I believe, but they rescinded such order or orders subsequently. And I'm not sure where the matters are now as we speak.
We'll get to that in a moment. But when the application to make the arbitration awards orders of court was made, you were not representing PRASA.
I stopped representing PRASA on the 8th. The applications,
on the day before.
The applications were in our possession already.
Yes.
And then PRASA opted to instruct another law firm
No.
to proceed with
No,
that.
I understand. We've been through that. I'm just asking, in the court process itself on the 9th, you had no role in that.
We were not involved.
And that's all, that's the extent to which your personal knowledge relating to the CIO matters extends.
That is correct.
Now, you make the point right finally that all of this is based, what's contained in your affidavit is based on the documents that were in your possession at the time you made this affidavit.
Correct. I had to pull out certain portions of the files from archives in order to prepare this affidavit.
Chairperson, those are the questions I have for Mr. Mogashoa, having regard to the fact that effectively from the 8th, he played no further role in this matter.
No, that's fine. I think it didn't occur to me that at the time of the application before
Acting judge.
I think an acting judge,
Yes.
that he was no longer involved.
Yes.
So when I referred to that
And-
special fish, I was talking about something that happened in
Yes.
court, thinking he would have still been part of it.
Yes.
No, so he wasn't. Now, you withdrew either on the 8th of March as the attorney of record for PRASA in regard to the CCA, in regard to the CIR matters, or soon after the 8th of March.
It may very well be that we filed our withdrawals on the same
day.
If Mr. Soni is right in suggesting that the applications were to be heard on the 9th.
Yeah, I think that's what we have been told. Now, when had you last interacted with the PRASA chairperson by then? Did you interact with her after the meeting of the 15th of December, between that date and the 8th of March?
The only interaction with her would be this email that she wrote to me.
Correspondence, yeah.
The correspondence.
But there was no meeting.
No, there were
no speaking on the phone with her.
We did not speak on the phone either.
You did not speak on the phone.
No.
What made you accept discussing the CIR matters with the legal department on the 8th, despite the fact that you had been instructed by the PRASA chairperson previously not to discuss those matters with the legal department?
I think part of it would be, or would have been, the frustrations I was experiencing in getting to know from PRASA what the firm was to do with the 4 applications, because up until that point, I had not received any indication of any kind whatsoever what PRASA intended to do with the applications. And I had no reason not to want to cooperate with Mr. Tingizwayo when he called and asked about the applications, because we had the applications in our possession.
But what I'm talking about is, I would have expected that, given the instruction that you told me about, which you said came from the PRASA chairperson to you, not to discuss the CIR claims with PRASA's legal department people, I would have expected that when Mr. Dingiswaya approached you and sought to make an arrangement, you would have gone back to the PRASA chairperson to say, you said I mustn't talk to the legal department. They have phoned me, they want a meeting. Do I stick to that instruction, or has something changed?
At the time...
And Mr. Dingiswaya knew that as well, because you told him.
Yes, at the time, Chair, and I think it must be taken into account that I was not talking to the chairperson directly, whether in writing, through email correspondence or otherwise. I had been communicating with or through the office of the group company secretary, Mr. Zide. It would have been irresponsible of me when, at the time I received a call from Mr. Tingizwayo, it would have been irresponsible of me to completely ignore what he had called me about, given the fact that I wasn't receiving any instructions. I was actually relieved that someone from PRASA called me about the matters. I obviously may have asked him what was going on, because I wasn't receiving any feedback or instructions from the channel or channels that I had gotten used to between December and March, when I started talking to him again. And as I say, I then decided to forward the applications to him without asking any further questions, because I expected him, as someone I knew was still at PRASA, to take responsible decisions around the applications. I had not been briefed on any aspect to do with the applications. I was worried that then PRASA was going to be unrepresented because I was not going to go to court the next day without specific instructions on what my family needed to do.
We know that the acceptance of the settlement agreement, of the settlement offer, was made around 17, 18, 20, 21 December, is that right?
Correct.
Now, after the offer had been accepted, there was that communication about payment. Matopo said, you know, please attend to payment urgently. And I think you would have sought instructions from the company secretary, is that right?
Correct.
Or maybe let me clarify that. Initially, you were meant to communicate with the board through the office of the CEO when Mr. Zide was the acting CEO. Is that right?
At the meeting of the 15th of December, I was not aware that Mr. Zide had stopped acting as the, Chair, as the group CEO of PRASA. But the instruction to me by the chairperson was that any communication must be through Mr. Zide's office.
Yes, my understanding is that when that instruction, or let me put it this way, was when that instruction was made, was Mr. Zide not acting CEO anymore?
I was under the impression that he was, but I think Mr. Soni.
Was it not on the? Was it not at the meeting of the 4th of December?
At the meeting of the 4th of December, he was still the acting CEO.
Yes, but when you were given this instruction, was it not at that meeting? Or was it at the meeting of the 15th?
It was.
No, it was at the meeting of the 15th, I think, because you then phoned Mr. Dingiswayo on the 15th, I think. I think you said that instruction was given to you at the meeting of the 15th.
It was given to me at the meeting of the 15th, not the 4th.
But you are saying that at that time, you were under the impression that Mr. Zide was still acting CEO.
I was under the impression that Mr. Zide was the acting
still
CEO.
acting, yeah.
Yes,
CEO.
Yeah, but I know him. I know him to be the
Company
or to
secretary.
have been the company secretary.
Yes.
So when the chairperson was giving instructions on how communication will be dealt with, I think to me it was more Mr. Zide as the person who works with the board, more than it was important for me to make that distinction whether he was still acting as the group CEO or he had reverted back to his original position.
Yes. But from January, had you asked for any instructions from PRASA and you didn't get a response?
I think Mr.
During
Soni
January,
took me through
February.
one attachment which I received by text. That's the meeting between, the meeting that the parties had decided to hold with Mr. Brand to confirm some of the settlements. But otherwise, so that's those are the instructions I received, because I had to take instructions on what PRASA wanted me to do with the fact that the plaintiff wanted to make those settlements arbitrators awards. The other normal communication would have had to be about payments that the CIA group was complaining were not forthcoming. And then the next big thing then was the applications themselves, which I forwarded to PRASA through the office of Mr. Zide, and what then transpired was Mr. Dingiswayo's call, and then the handing over of such applications to him.
The meeting of the 8th of March, you say it included Mr. Zide?
Mr. Zide was present.
Yes. Yes. So, you see, I was just concerned that you didn't go back to to the chairperson when now it seemed that you were going to meet with, to discuss CIR matters with people that he said you mustn't discuss them with, but there was Mr. Zide who was there.
Mr.
And
Zide
maybe
was
that is
present.
what that made a difference to you.
Mr. Zito was present, and yes, it
Yeah.
made a difference to me.
Yeah. Okay, no, that's fine.
And possibly when, I'm probably correct in making this suggestion. When Mr. Dingizwayo asked that I forward the applications, we in all probabilities CC'd Mr. Zide. Because I had no reason to want to not have him know
Yeah,
that legal had asked for those applications from me.
yeah, yeah. Did you ever deal with Mr. Mulepo? I think he was the acting CEO after Mr. Zide ceased to be acting CEO.
No.
You never dealt with him? Yes.
The first encounter, Chair, was that meeting and nothing ever since.
Or was he present at the meeting of the 8th?
He was. I think the meeting was called by his office.
Or Mr. Mulepo?
Yeah, well, seemingly at the insistence of legal,
Oh,
which had become aware about the
yes,
applications.
yes. Are you able to tell what his attitude was to these settlements that had happened, or are you not able to tell from the discussions at the meeting of the 8th, or the whole topic was different by that time?
I think he was concerned because he did not have any trouble
With the
having
proposal.
legal proceed with
Yes,
the opposition that they had intended
yes,
mounting against the application. So,
yeah,
in as far, well, to that extent, one thinks that he agreed,
yeah,
or he was in agreement with
with that
legal
approach.
that a different approach should be
Yeah.
taken.
Yeah. The idea that the settlement agreements should be made arbitration awards, was that part of the settlement agreement? Was there a clause in the settlement agreement that said that? Just seems strange to me that unless it's included in a settlement agreement, it seems strange that I'm going to agree that I'm going to pay you and we sign. And then I also agree that let's make this an order of court. But if at the time we made the settlement agreement, that was part of the settlement agreement, that may be different. Because otherwise, if it's not part of the settlement agreement, if I've agreed that I'm going to pay you, then I pay you within the time that I've agreed to pay you. And of course, if I fail to pay you, you might have cause to want to make the settlement agreement an arbitration award or order of court. But normally you'd wait until you see whether I've complied. I just find it strange that PRASA, you were instructed to agree to having the settlement agreements made orders or arbitration awards.
I think if you look at the timelines, Chair, if we accept that the settlements were agreed to around the 21st of December,
December, yeah.
this is now beginning of February that
Yes,
Mr. Matopo is beginning to complain. And,
the period of payment had expired.
well, reasonable period
Yeah.
had expired, although
Was
I
there not a
doubt-
specific period mentioned, like 30 days?
I doubt that the tenders had stipulated any period.
Yeah, or,
I think, because otherwise we would be making a lot of reference to the period
yes, yeah,
referred to in the tenders. So
Yeah.
they probably thought that whatever number of days that may have lapsed since they accepted the offer
yeah.
were enough to have them start complaining about the fact that they're not getting paid.
Okay, no, that's fine. Anything arising?
Nothing else.
Nothing. Thank you very much, Mr. Mogashoa, for having come to assist the commission. We appreciate that you may have been like us. You thought this might have taken 2 hours. It ended up taking the whole day, but we appreciate that you came and you have given your evidence. Thank you very much.
Thank you, Chair, and I'm glad that I could be of some assistance.
Yes, you are excused.
Thank you very much.
We are going to adjourn for the day, and tomorrow the sitting will start at 10. At 10 o'clock. We adjourn.
Oh, no.